Good day, students, and welcome back to our class. So, here in our class, in 3222, or the fundamentals of criminal investigation and intelligence. So, bago ko simulan ang klase natin ngayon, gusto kong sabihin na hello and welcome back to school. Now, ano nga ba ang 3222? So, what is 3222? So, ang 3222 ay pinagsanib-buwersa ng investigation at intelligence. Anong ibig sabihin nun, ma'am? So, kung ibig sabihin ng investigation ay merong tao na investigator or siya yung maghahanap ng mga ebidensya laban sa isang tao dahil may naganap na krimen. Or there is a crime situation that needs to be solved. Alright. Ma'am, bakit may intelligence? Kasi kapag nag-iimbestiga ang isang investigator, kailangan niyang gamitin ang katalinuhan niya. Paano? Malalaman natin ito sa susunod na mga topic or mga paksa. Ngayon, simulan na natin ang ating pag-aaral sa CRE 222. Ngayon, may nakalagay dito na crime. So, ang crime is an act or any act considered as wrong or violates the standard norm of the society. In legal perspective, crime is an act or omission in violation of the law. Here, crime may be committed either. There are two. So, palawakin muna natin ang pag-unawa natin sa salitang crime o krimen. So, lahat ng bagay na mali, no, na hindi gawain ng isang mabuting tao o yung tao na may saktong pag-iisip, no? Ang lingid sa social norm ng isang bayan or lugar, kung mali yung ginawa mo, ang tawag doon ay crime. Okay? Hindi ibig sabihin na hindi ka pumatay ay crime na. Kasi ang crime, there are two types, no? There is committed and violates. Okay? So, committed. These are acts that are being performed injuries or otherwise deprived the individual of either their lives or kung pumatay or a person killed a person, another person, or a property. No. So, hindi lahat ng crime, not all crimes that are considered na tao lang yung nag-commit ng crime or kinumita ng crime. Ibig sabihin, meron ding crime laban sa bagay. Ano yun? Yung theft or robbery. Kasi crimes against property iyon. So hindi lahat ng crime or not all crimes are committed to a person, no? It can also be things or properties. Now, a crime also is also known as a crime that violates. Okay, it violates because the standard norm of the meaning of the society itself is considered an act as a crime. So, kung lumabag ka sa standard norm, kagaya ng sinabi ko, o yung hindi mo pagsunod sa batas, that is also considered as a crime. Next. Crime legally and generally is an act or omission that violates the law And some terms must also note as they might be confusing and interchangeable with the words crime, such as felony, offense, and misdemeanor. Okay, felonies are those crimes that violates the revised penal code of Article 3815. No, yung lahat ng nasa RPC. Okay, offense. These are acts which are defined as crime as a result of the special law enacted by legislatures or yung tagagawa ng batas natin, legislation office, no? Next, misdemeanor. These are minor violates or infractions not tantamount to serious injuries or damages. So yung maliliit or small offenses lang, no? These are called misdemeanor. We have here next is law. So it is a system of rule embodied by different principles that binds the practice or action concerning human conduct. In the eyes of the law, crime can be committed, it can be an act or an omission. Okay, ang law ay batas, no, na sinusunod ng lahat ng mga tao. So there is no law if there is no crime punishing. There is no crime if there is no law punishing it, okay? So, yun. Yung law ay ang batas, no, na sinusunod ng tao. Because if there is no law, the community or the world will be chaotic. Ibig sabihin nun, magulo. Kasi lahat tayo, walang sinusunod na batas kasi kanya-kanya yung batas na ginagawa natin. Now, an act, it can be performed by the offender that is contrary or violates the law. Next, omission, which the offender fails to perform certain acts as required by law. Okay, Revised Penal Code, RPC, and Special Penal Code. Okay, Revised Penal Code define those acts as crime which by nature or evil, as well as provide nature, penalty, and elements to determine such crime, which includes but not limited to murder, homicide, theft, and robbery. Okay, so yung RPC natin nandoon lahat ng mga crime na those are known as evil, no? And yung mga nakakasira talaga ng buhay ng kapwa nating tao or tapos nagpo-provide din siya kung bakit nako-commit yung crime na yon. And then paano yung ways of penalties, no, kapag na-commit yung specific na crime. And then ano ba yung elements ng crime, no? Okay? So there are lots of articles, no, in the RPC. And next is special penal laws. So laws which makes an act as a crime as a result of enactment of law as crafted by the Congress in the form of Republic Acts. Next. Okay, let's proceed to criminal responsibility. So here, an investigator has a criminal responsibility because uh, the investigator has a supremacy, no, to do things, but he has some limitations. Okay, so now criminal responsibility is an obligation of the person for the charges as a result of his criminal act. Okay, so if a person commits a crime, then he is responsible of his acts. Okay, so the result of his acts, no, he is responsible. So it can be affected by some other factors such as if he of the age, if he or she has a correct sound mind, or yung ibig sabihin nun, he is mentally retarded, no, or hindi niya alam kung ano yung tama at saka mali. And technically, the term minor child or children refers to someone who is not yet in their puberty stage. So, kung isang tao ay nakakommit ng crime, and a number one factor na may criminal liability siya or responsibility if yung tao na yun ay nasa saktong pag-iisip. Pero, Pero this is an exemption of the criminal responsibility because kung ikaw ay bata, hindi ka pwedeng akasuhan kung ikaw ay um, hindi matino. Okay? If you have um a sickness, no, or ill. Okay? And then, if someone is not yet in their puberty stage, okay, let's discuss this. Puberty, the stage wherein the child is already capable of reproduction. Ibig sabihin, kung ikaw ay nasa yung binata at saka dalaga na, ibig sabihin nun, nasa saktong pag-iisip ka na. No? Or, yung mga malalaki ng ate, kuya, or yung mga oldies natin, kumbaga. Now, child is a person below the age of 18 years old, no? Refer this to paragraph 5, section 4 of RA 9344 as amended. So, children, legally defined and refers to persons under 18 years of age. So, ibig sabihin, a child or children, no, they cannot take care of themselves, no, fully kasi bata pa sila and they are not yet on their exact minds. Ibig sabihin, they um can be also abused, no, and neglected and exploited because they cannot know what is right and wrong, and they're unable to fully take care of themselves, no, because they're not physically and mentally nga trained or developed. Okay? Next is lunatics. So, this is what I'm talking about, that these individuals are their minds are in a state of sickness or illness. Ibig sabihin, hindi nila alam talaga yung tama at mali. Um, if a person is a lunatic, no, kahit na your age is 50 years old, yung um, the way you speak or the way you act is like a 2 years old na newborn or child, no, kasi nga hindi nag-develop ang kanilang brain. Okay, so you are not criminally responsible if and only kung may sakit ka sa utak, bata ka, at yung below 18 years old. Okay? Next, we have the police power. So, police power is necessary as it is one of the regulatory of the government to control, maintain, and ensure that the conduct of its people is within the bounds of the law. So, ibig sabihin, si law enforcing officer ay mayroong responsibility na pangalagaan ng peace and order in the community. So, he makes sure that the laws were being abided by the citizen or the people. So, that is the primary job of the police. Now, investigative police power is the capacity of the police to initiate investigation cases which violates the law. Now, it is being specified here that a police has the power to investigate when he is given the chance, no, or the uh, responsibility to investigate. The police has the power, no, to conduct investigation cases. He has all the power, however, also constrains their capability and lengthen the time to finish investigating certain case, as the state also recognizes and protects the fundamental rights of every person subjected to investigation and maintain presumption of innocence. Now, so when a police officer is an investigator, so the police, no, or the investigator has the power, no, to apprehend a person. So when the investigator or the police apprehended a person, the police should always presume the innocence of that specific person. That is because we have a law that says that every person subjected to a criminal case is deemed considered innocent unless proven to be guilty beyond reasonable doubt. So, who can say that a person is not innocent and is guilty? That is the court. Okay, let's go back to your CJS, the five pillars, no? Namely law enforcement. Next is prosecution. Next is court. The fourth one is the correction facility or the correction pillar. And the last one is the community. Okay, so beyond reasonable doubt is a principle that states that a person is guilty based on moral certainty. So, what do you mean by moral certainty? So, this is a sense that a person is guilty based on how the court appreciated the evidence presented during trial with which produces a conviction. Okay, so when the evidence is enough and it has been proven no to the court, and that is the time that there is a conviction. Okay? So, use of moral certainty, it is the person is being guilty no based on the facts or the evidences that are being presented no. Okay? So, if he is being if the court has convicted him no for final judgment, that is the time that that specific apprehended person will be convicted no, that is final no, and that is um, unrevocable. Okay, so when that person is being convicted, he's now that accused person is called the person deprived of liberty or the convicted person. Now let's proceed to substantive and procedural criminal investigation. When we say substantive criminal investigation, this refers to the knowledge, nature, and implications of the different crimes that the investigator should know and possess. So an investigator should um, know the proper rules on how he should investigate no a specific crime or the crime scene. Next, procedural criminal investigation. So the investigator must have the knowledge no regarding the rules on how physical evidences should be processed in order to maintain in integrity during presentation and be given credit by the trial court. So the investigator should have the knowledge no para malaman niya kung para gawin niya ng tamang kanyang trabaho at kung makakuha man siya ng evidence galing sa crime scene, it should be, you know, it should be nga yung ano talaga, it should be preserved, no? It should be, the procedure should be followed and it should follow the chain of custody. Now, next is crime scene. So, it is a simply the area where the crime took place and where all the physical evidences were gathered and collected. So, yung pinangyarihan ng krimen or yung crime scene. It's just the scene, oh. Crime scene is also known as the most favorite words of the criminology people, known as corpus delicti. Okay? Now, let's have the admissibility of evidence. So, these are evidences in any crime that dictates the outcome of the case as a result of criminal investigation, as these are the primary source that will serve as the basis in prosecuting a person who will be held for trial. In the Philippines, the RPC provides for the requirement as to how individual evidence will be admitted, such that, so, ibig sabihin, admissibility of evidence, kung yung evidence mo ay sakto, tama, at related sa iniimbestihang kaso. Okay, paano mo malalaman na tama yung mga evidence na binigay mo? So, magbabase tayo sa nakalagay sa RPC, no? At saka sa revised rules of court because there are some um, rules, no, na dapat i-follow. So, these are evidence must be relevant. Okay, it should be connected, no, logically connected to the issue brought before the court. So, if the crime is murder, there should be a murder weapon, no? There should be evidence na um, there is kanang gun or maybe kanang um, kutsilyo, 'di ba? So that is how should the evidence must be relevant. No, it should be connected to the crime that is being committed. Next, evidence must be competent. This just means that hindi mo tinamper yung evidence kasi dapat correct ang inyong binigay na evidence. Next, under the law, there are three general classifications of evidence that the investigator must remember, such as object evidence. So, these evidences are physical, so it can be seen, it can be physically na mahawakan natin. So, most of these are yung nare-recover sa crime scene. So, yung makukuha sa crime scene, those are object evidences. Now, testimonial evidences. So, these are evidences that are being gathered from a witness, no, or who has the knowledge. So, these are commonly given by a person, no, orally. Okay, next, documentary evidence. These are those evidences in document which include e-evidence or electronic evidences such as text messages, chat messages, electronic mail, and other evidences which are printable. Okay, so dati, yung evidence na documentary lang ay yung mga written, no? Nung nakasulat talaga, pen and paper, ball pen and paper. Pero ngayon, because since nagka-evolve na ang ating society, no, ang ating world, so there are also na mga electronic devices such as text messages. So ano yon? Yung mga spam messages, yung mga phishing messages, kundi yung chat, binablockmail sa chat, ganon. Electronic mail, most commonly, no? Gmail, Google Mail, Yahoo Mail, and other evidences which are printable. It can also be screenshots, no? If you are being blackmailed, no, on social media or you are being bashed on social media, mostly naman yung evidences na ginagather are screenshots. So, anything that can be printed, no? So, those are considered as documentary evidence. Now, we also have other classes of evidences. So, these are direct evidence, an evidence which directly proves the case under investigation. Circumstantial evidence, these are combinations of different events which is combined maybe produce conviction. Corroborative evidence, these are evidences which has a different character form than the one previously offered. Cumulative evidence, these are evidences which has similar nature and character to the one previously offered. Positive evidence, an evidence offered by a witness in which he clearly manifests that an event or scenario exists or did not exist. Negative evidence, an evidence offered by a witness in which he is not certain as to whether an event or scenario exists or did not exist. Now, prima facie evidence or prima facie evidence, an evidence offered which may produce a conviction if no rebuttal. Evidence can be shown a rebuttal evidence and an evidence offered to contradict an evidence previously offered. So these are some of the classification of evidences. Okay, these uh, things are gonna be elaborated on your law. Okay. Now, that is the end of Ulu A from week 1 to week 3. Thank you for listening. I hope you learned something and I'll see you on my next class. Thank you and God bless. Keep safe, everyone.